All rise. Ladies and gentlemen, the Supreme Court of Alabama. Hear ye, hear ye. The Supreme Court of Alabama is now in session. God save the state of Alabama and these United States, and bless this honorable court.
Be seated. Madam Clerk, if you will call the case, please.
Case number SC 2025-0293, the City of Mountain Brook, Alabama, v. Rodney E. Miller and Mary Leah Miller. This is an appeal from the Jefferson Circuit Court. Arguing for the appellant, the Honorable Ben Presley, and arguing for the appellee, the Honorable Rodney Miller.
Mr. Presley, are you ready?
Thank you, and may it please the court. Ben Presley on behalf of the appellant, the City of Mountain Brook. With me today is my law partners, Tony Davis and Sybil Newton. We also have with us today several of the Amici counsel. There was an amicus brief filed by several cities, including Montgomery, Mobile, Tuscaloosa, as well as some smaller cities like Thorsby and Columbiana. This is an important issue, an important case for cities across Alabama. It involves municipal liability for flooding, and I appreciate the court's time today. It arises out of a flooding event which occurred on May 15th of 2023. There was a 50-year rain event in the city of Mountain Brook. It caused flooding in numerous places, including the property located at 2801 Montevallo Road, which is owned by the Millers. Flooding was significant. There were several feet of water that entered the basement of the residence. This was not the first time that residence had flooded. It had flooded to that extent on numerous occasions before. In fact, the prior owners of the property had even submitted a notice of claim to the city outlining some of those events, and the documentary evidence in the record reflects flooding problems and drainage issues at that property dating all the way back to 1950. The Millers bought that property 10 days before the flooding event occurred on May 5th. The Millers testified below in discovery that they asked questions about the flooding history of the property and did not receive fulsome answers to those questions. The full history of the flooding at the property was not disclosed to them. After the property flooded, the Millers sued the city. They sued the city on theories of negligence, trespass, nuisance, and also sought permanent injunctive relief from the city. Discovery ensued, and the parties filed cross motions for summary judgment on the issues in the case. The trial court denied the city's motion in full and granted the Millers' motion, awarding approximately $80,000 in damages against the city and entering a permanent injunction against the city, enjoining the city of Mountain Brook from flooding 2801 Montevallo Road in perpetuity.
So the trial court mainly relied upon this Beatty case, right?
She did.
Distinguish it for me.
Sure. So Beatty's 1974 case, distinguishable in several respects, and I'll go through each. The first would be that Beatty involved a prescriptive easement. A prescriptive easement is an issue that this court has described as one as rarely litigated in this state. It's important that it involved a prescriptive easement because that was the source of the city's claimed rights in the Beatty case. The issue in that case was whether and to what extent the city had any rights to discharge stormwater into an unimproved natural ditch that ran across the Beatty property. The city neither owned that ditch nor had a recorded or dedicated easement over that ditch. The city had discharged water into that ditch for a period of 20 years. Therefore, this court found that the city had acquired a prescriptive easement to do that, to discharge water into that ditch, and that necessarily the bounds of that prescriptive easement were consistent with the city's prescriptive use over the requisite 20-year period. Here, we're not talking about a prescriptive easement. What we're talking about here is a dedicated easement to the city for the purpose of stormwater infrastructure, and there is a pipe in the easement at issue here on the Miller property in this dedicated easement, where a city has a dedicated easement or owns property where there is drainage infrastructure, 115050 of the Alabama Code gives cities the express authority to construct and maintain infrastructure on both public and private property. Public property being owned by the city, private property necessarily requiring an easement. And this court's decisions are absolutely clear. When you are talking about a city exercising its authority under 115050 to construct or maintain drainage infrastructure, there is a negligence standard that is required. So the right of the city to do that derives not from a prescriptive easement, but from statutory authority and a dedicated easement. So that's the first important distinction between this case and between Beatty. We're not talking about a prescriptive easement over a natural ditch in this case. It's a dedicated easement for the purpose of stormwater infrastructure. The city can maintain infrastructure in that easement so long as it does not do so negligently. I would also note that Beatty was decided 8 years before Rich versus City of Mobile, which established substantive immunity. And so Beatty obviously had no occasion to address substantive immunity. It was actually decided before this court's decision in the city of Jackson versus City of Florence case, which abolished absolute municipal immunity and recognized the legislature's intent in 1147-190 for negligence actions against the city. And 5 years after Beatty, this court made clear in the City of Birmingham versus Fairfield decision, went out of its way actually to devote some time to discussing Beatty and explaining why that case is inapplicable in situations where a city is exercising its authority under 115050 to either construct or maintain stormwater infrastructure. So for those reasons, Justice Cook, we would say that Beatty is distinguishable from this case. And the trial court wholesale relied on Beatty. It was the first reason the trial court gave for why the city why the plaintiff did not have to prove negligence by the city. In effect, imposed a strict liability standard. Doesn't matter the size of the rain event, doesn't matter what the city has done to maintain that easement, maintain that pipe. There's no evidence in this case of any blockage, of any collapsed pipe. There was actually a video inspection after this flood, which confirmed that the pipe was clear and free-flowing. The pipe was not in any way improperly maintained as that term has been defined by this court's case law. So we would say that the court erred in relying on Beatty to impose strict liability and also erred in relying on Beatty to impose permanent injunctive relief.
How would you distinguish the Kennedy v. City of Montgomery case?
So Kennedy versus City of Montgomery, I believe that was a 1980s case. This court actually talked about Kennedy versus City of Montgomery in the Muscle Shoals decision, I believe. And there were two recent Muscle Shoals decisions, one in 23, which I believe you wrote, Justice Cook, and then there was a 2025 follow-up decision by Justice Bryan. So it's okay, I'll refer to him as 1 and 2 in that regard. But Kennedy was addressed in Muscle Shoals, and the plaintiffs in Muscle Shoals brought up that case. Kennedy, importantly, reversed summary judgment in favor of the city and said there's issues to be tried here, but we are not reaching the question of whether a city's decision to expand or upgrade pipes, which the evidence in Kennedy reflected would cost between $500,000 and $1 million, is culpable conduct or a policy decision. I think this court's substantive immunity jurisprudence, especially since 2023 and forward, clearly stand for the proposition that a city's decision about whether to upgrade stormwater infrastructure, because it's important here to remember there's no allegation that this infrastructure was improperly built or improperly designed when it was put in. The theory here is, well, it's existed in its current state for a long time. There's been developments in nearby property, and therefore it has to be upgraded. That theory of liability it's a public policy decision, I think, is what this court's substantive immunity cases recognize, that when you are asking the question of when is it appropriate to update stormwater infrastructure, you're necessarily asking questions like, how much does it cost? Where are we going to get the money? Should we spend it someplace else? These are questions the city is asking itself. When do we do it? Do we do it as soon as regulations change? Do we do it when there's an event, a flooding event? Do we do it only when there's a severe event? And the city wrestled with those exact questions in this case. There was a study in 21-22 by Shoal Engineering, preeminent engineering firm in Alabama. And it wasn't the only study. There have been studies previously, but the 2021-2022 study by Shoal looked at this area, and not just the Miller's property, but the larger area around the Miller's property outside Mountain Brook Village. And they came up with a preliminary 3-phase plan because this area has historically flooded. The cost of that plan was $3.9 million and change, and the cost was projected to increase. Shoal projected it would increase because there was going to have to be additional work done even further downstream to account for a rise in water levels that this work would actually cause. So you got the cost. You had letters written to the city by its citizens who were downstream from the Millers that vehemently protested to this work and in fact threatened to sue the city if it went forward. You have Shoal's opinion that I wouldn't undertake this project. They recommended to the city after designing the project that they do not recommend the city go forward with this project because they believe that the cost outweighed the benefit. And on top of that, you've also got Shoal opining that with respect to 2801 Montebello Road specifically, the Shoal 3-phase project at a cost of nearly $4 million and likely more is not going to solve the problem at 2801 Montebello Road, which has flooded historically for decades. So
I do want to follow up there. My understanding is, like you say, it's flooded for decades, and the city's had notice that it was flooding for decades. The city's actually not done anything, though, right?
the city has not performed any improvements to near that area. I believe there was an additional pipe added around the 50s. If memory serves, I believe Walter Scholl speaks to that in his affidavit.
How did the city end up with this stormwater system? The city of Mountain Brook's what, from 1942 created, right?
Correct.
This was built in 1928. So how does the city get ownership of this?
Right. So the original developer of Mountain Brook Estates, there's actually a case that speaks to this from the Alabama Supreme Court. It's Mountain Brook Estates versus Solomon. The original developer built the infrastructure, designed the infrastructure, and then dedicated it to the city, and the city accepted that dedication and the concomitant responsibility to maintain it in a non-negligent manner. So that's how the city came to have the responsibility under 115050 to maintain this infrastructure.
Have we ever applied substantive immunity to stormwater cases?
Certainly. Substantive immunity was applied in your opinion, Justice Cook, in the first Muscle Shoals case. So you applied substantive immunity to dismiss a claim for injunctive relief that was asserted by the citizens in that case against Muscle Shoals. Substantive immunity in the second Muscle Shoals opinion was heavily discussed, but in that opinion, the only claims left were two damages claims. And I believe the opinion acknowledges that the questions about a city's decision to plan for larger events, design for larger events, touch on issues of substantive immunity, I believe is the phrasing, but the court didn't reach the issue of whether it actually barred it in that case because it found other deficiencies, namely a lack of negligence. And then finally, I would also point the court to Justice Mitchell's recent concurring opinion in the Britt versus City of Hoover case, which involved a case where the City of Hoover, much like Mountain Brook, had received a study from Shoal Engineering, proposed updating enlarging infrastructure. And in that case, it was affirmed, and then Justice Mitchell wrote a special concurring opinion, and Justice Mitchell had a very good, very thorough discussion of why substantive immunity barred the injunctive relief claims in that case.
If we were to clearly state that substantive immunity applied to drainage cases, would we have to overrule any other cases?
No. Very quickly, one other issue here is that the trial court in its summary judgment order contained a secondary finding that even if negligence is required, then there is substantial evidence of negligence. Actually, negligence is a matter of law in this case because the city has failed to update and enlarge its pipes and infrastructure in this area. We believe that that theory is squarely foreclosed by this court's decision in Byrd. I see my time is up. May I finish?
Finish your sentence, Mr. Presley.
Thank you. We believe that theory of liability is squarely foreclosed by this court's decision in Byrd versus City of Citronelle and the Alabama Court of Civil Appeals decision in Long versus City of Athens, both of which stand for the proposition that a theory to upgrade or enlarge infrastructure sounds in design and construction and not maintenance. Thank you.
Okay. Thank you, Mr. Presley. Mr. Miller? Mr. Miller, I understand that you have some exhibits to show us today. Are all those in the record? I'll have no objection to. Okay, just so that we're clear, we're in appellate court. Okay. Right.
So Chief Justice Stewart, honorable justices, I'm Rodney Miller, and I'm here on behalf of myself and my wife over there. This is a nuisance and trespass case. It involves the City of Mountain Brook's rights and duties as an easement holder. And the question presented is whether easement holders must abide by the scope of their easements. As you just heard, it is not in dispute that the city has a 12-foot wide drain easement along the side of our property. It's here in the yellow. This in green says 12 feet. It is also undisputed, as you heard, that water is coming out of the city's drain, up through the city's drain inlets in this easement, and onto our property outside of the easement. I personally witnessed this on the day in question, and it's been admitted by the city in a variety of ways we detailed in our brief. Now, at the summary judgment hearing, what the trial court actually granted summary judgment on was our nuisance and trespass claims. And the city has not substantively opposed our nuisance and trespass claims, other than to say in a footnote, I think it's footnote 8 of their appellate brief, that these claims depend on the viability of, I guess, an underlying negligent construction or negligent maintenance claim. To that point, I ask you to imagine if instead of a 12-foot wide drain easement, imagine that the city has a 12-foot wide right-of-way easement. And instead of flooding our driveway and our garage with water, imagine that the city drives onto our property through their easement, goes outside of their easement, and parks a vehicle in our garage. If the city did that, it would be a trespass interfering with our exclusive use of our property, or possession of our property. The vehicle in our garage would be a nuisance interfering with our use and enjoyment of our garage. Under either scenario, whether they're parking a vehicle in our garage or flooding our garage with water, the city would be in breach of the standard of care that they owe as an easement holder, and that's what this case is about. Now, in the City of Mountain Brook versus Beatty case, which you already mentioned, Justice Cook, the plaintiffs did not assert a negligence claim. The words negligent and negligence are nowhere to be found in that case. They brought a nuisance claim related to the City of Mountain Brook overflowing from an easement and flooding private property. And in that case, this court held and recognized that easement rights are not without limits. And when a municipality claims a right to drain through an easement It has a duty to maintain that easement so that the water, and I'm quoting here, would not overflow to the damage of adjacent property. And that is exactly what is happening here.
But when you have a 50-year flood event like that, how do you take that into consideration of what the duty might be? You know, you have something unusual like that. Is the city required to factor that in as well?
Well, regarding the severity of that, I would like to note that this was the 7th time in 2 years this home had flooded. This was not a severe or unusual rain event. The parking garage they're discussing as flooding is actually underground. No other houses around us flooded, just ours. And that 50-year rain event in 2023, the one we're here about, Shoal actually did a study on a rain event in 2021, and it was a 100-year event. So this is not based on the severity of the storm, but regardless, as I'm about to show, the city has a duty to maintain its easement. When they collect stormwater and direct it to our property, it is their responsibility to make sure that water stays in its easement. Every bit of water that came onto our property that day came out of their drain easement. This is not surface water from the storm. This is water they are capturing, collecting, and directing to our property, and knowing, and they're well aware that when they do so, water is coming out of it because the drain is, as their experts say, it just doesn't have the capacity any longer. It was put in at least 1928. The Platts recognized this 36-year drain there, and it is still there.
Now, how does I'm over here? Yes. How does substantive immunity apply? Because we have, the Rich case, which we recently reaffirmed in Ex parte City of Orange Beach, applies substantive immunity to certain public services of the. So I know Beatty was decided before Rich. How do they mesh?
So regarding substantive immunity, I want you to, if you can notice this photo here, that's a door to our house after one of the floods. And you can see the water line is up to the door handle. So that's over 3 feet of water. So I want you to know that when they're asking for substantive immunity, that's what they're seeking permission to continue doing.
Well, that's a good jury argument. But my question is legal. How does substantive immunity, does it apply? Does it not apply? If not, how do you distinguish that the Ex parte City of Orange Beach and Rich from Beatty, or is Beatty, how does it mesh with those, I should say?
So this court, in looking at the substantive immunity issue, especially in a lot of the recent cases, it looks to whether the municipality owes a duty to the individual plaintiff, right, or is that duty merely incidental and owed to the general public? Well, in this case, Beatty acknowledged that when a city drains through an easement, where that's what the basis of the rights are, that carries with it a, quote, corresponding duty to maintain the easement. And that's a legal correlative where the existence of their right necessitates the existence of the duty. In other words, they can't obtain a right to drain through an easement without also obtaining the duty to not overflow and flood outside of it. And so
you're saying an easement makes a difference. Is that the distinguishing factor here between your case and this City of Orange Beach, the Rich substantive immunity cases?
Correct, Justice McCool.
Okay.
The duty in this case arises by virtue of the easement. It was recognized by this court in Beatty and City of Birmingham. It's fixed by law, and it's owed by the municipality as the easement holder directly to us as the landowners. It is not incidental, and it's not owed to the general public.
Mr. Miller, I'm struggling here with a similar question to Justice McCool. So I understand your argument to relate to duties that arise out of or the boundary line of your easement. On the other hand, I read our cases involving substantive immunity to kick in when certain governmental activities or governmental services are involved, such as stormwater drainage. I'm curious, sort of a similar question to what Justice Cook had when your friend on the other side was up here. Do you have any case law that can help us understand why this immunity that applies with respect to services does not trump everything else? Where's that legal authority that says, I can see that the immunity applies to services, and I think stormwater, I'm assuming you may have an argument about it, but I think that stormwater drainage would be one of those services. If that's the case, why does that not resolve the legal question that we're here on?
Well, actually, that's not the case. If you look at City of Mobile versus Sullivan, the court acknowledged, quote, there is a long line of cases holding municipalities generally liable for failing to properly maintain their drainage systems, and it is repeatedly I guess, put in the same context of liability of the municipality when it comes to streets and alleyways. You can also find this in the Long versus Jefferson case, where the court specifically rejected applying rich and substantive immunity. And Justice Cook asked if you all would have to overrule any cases. You would have to overrule that long line of cases. The city actually cited to several cases, Kennedy versus City of Montgomery, and even City of Mobile versus Jackson, which specifically rejected the application of rich and substantive immunity. What you will see in these cases is that the court repeatedly finds that municipalities, when exercising the right to drainage, they have a duty, and their duty is kind of correlated to that of roads and alleyways. The city has not provided a single case where involving an easement where substantive immunity has overridden or usurped the duty of an easement holder. Not one, and I haven't found one. The cases they rely on, like Britt versus Hoover and Muscle Shoals, they lack a duty owed to the plaintiff, or they involve a plaintiff seeking an injunction to get a city to enact a new ordinance or enforce an existing one. But none of them involve an easement and override this duty. And I think that's the key here when you look at the duty, because this duty is not owed to the general public for services. The residents of Mountain Brook in general, whether 5 houses away or 5 miles away, are not owed a duty because of the city's easement on our property. It is our property that is burned by and subservient to the city's easement. And because of that, the duty is owed directly to us and only to us. And if you look at former Justice Mitchell's opinion that he wrote in the Britt case, you will see he details, we look at duty. This is a narrow exception. And he even said what I think is interesting about that at the end. He says that he does not believe this holding in Britt, that his decision in Britt that he wrote about, does anything to change the precedents we have where the city owes a duty to the plaintiff and causes the flooding. And that's what we have here. But actually, there are a lot more cases where substantive immunity has been rejected. The cases where it's been applied have been where people are trying to force the city to enact a policy or something like that, not when they owe a specific duty to us that arises by virtue of the easement.
Well, just to be clear, those cases like the city of Mobile and so on, those dealt with negligent construction / design or negligent maintenance, right?
Correct.
And so here you're asking for the city to upgrade its system, right?
Actually, we are not. We never asked for that. That's what they put in their brief. But
in your complaint, you're citing these studies by Scholl and other engineering companies that had plans to redesign the whole system, right?
We discussed those in the introduction section of our complaint. If you go to C104 through 107 and look at our actual causes of action, you will see the Scholl project is not mentioned at all. We did not bring a cause of action for failure to do the Scholl project.
But you would agree with me that there's no evidence that this flooding event was because of a failure to maintain the pipe on this property.
No, I would disagree with that. Every ounce of water that came onto our property came up from their
right. They sent a camera through the pipe, right? And
yes.
There was no obstructions in that pipe, right?
Yes.
And there were no leaks in that pipe, right?
Correct.
Yeah.
So, and so I guess to get what you're saying, you're wondering if they failed to maintain it like there's an obstruction or something. And that's what I was about to get to in Beatty is that, well, I guess let me move to City of Birmingham, and I think that'll answer your question. So in the City of Birmingham case, the court held that to obtain an injunction pursuant to a nuisance, you have to provide evidence of negligent construction or negligent maintenance.
Right.
However, this court said, should our decision in Beatty be considered as contradicting with City of Birmingham, we point out that they're distinguishable. And what the court noted is that because Mountain Brook had an easement, they were, quote, subject to a duty to maintain that easement so that adjacent property would not be unduly burdened. And the court also noted that Birmingham did not have an easement over the property they were flooding. And because of that, they had to, the plaintiffs had to provide some evidence of negligent design and construction. So what this court noticed is that because of the easement, there was a duty that existed in Beatty that did not exist in City of Birmingham. And they acknowledged this. I would invite this court to go to pages 28 and 30 of the appellate's brief, and they recognize that the legal duty in Beatty is materially different and, quote, fundamentally different than that in City of Birmingham and the other municipal drainage cases. And I respond to that by saying, exactly. because Beatty involved an easement. It turned on the rights and duties of an easement holder. It turned on the standard of care that an easement holder owes, even a municipality, when their rights to drain are based on an easement. And this court distinguishing Beatty from City of Birmingham in that actual brief indicates to me that the justices at that time thought someone might come along one day and make the very argument that they're making, that they will come along and say this requirement for proof of negligent construction and negligent maintenance applies in an easement case. And fortunately, this court put an end to that argument before it could be made by distinguishing Beatty from City of Birmingham in City of Birmingham.
The undisputed evidence here, right, is that the mistake, the negligence you're claiming by the city is the failure to upgrade their system.
No, our negligence claim is based on their easement overflowing and flooding our property.
But you agree that it's overflowing and flooding your property because they failed to upgrade their system.
Well, that's what we didn't seek an injunction for, because
that's what the evidence is.
But the injunction is a permanent injunction to stop flooding.
Correct.
How is that injunction going to be enforced without these upgrades to the system, which Bubba Scholes basically says are not going to affect, any situation with your house, even if they adopt the $3 or $4 million improvements?
Okay, so as far as Mr. Scholl saying that, I'll answer that first, then get to your other part. Mr. Scholl actually designed a project that he represented would significantly reduce this flooding. It states it in the report. He presented it to the city council by saying he was confident it would mitigate flooding. So if he has now changed his decision and doesn't think it would work, I would advise the city to hire their other expert, Mark Simpson, who also works at Shoal and was deposed. And he said this would reduce the flooding, that this would help. In fact, he said until they do something like this, it's going to keep happening.
So the injunction was stop this, right? It's an impossibility, right?
Correct. So the injunction in Beatty, and I think you two are on the same page. In Beatty, what this court said is the trial court, nor this court, is what the court in Beatty recognized, cannot dictate the means of preventing the overflow. But the municipality should be enjoined from overflowing, and how they do it is left to them.
But how they do it imposes a burden on the rest of the residents of this city with either raising taxes or floating bonds or doing whatever it is. And so you're putting that responsibility back on the city, and that goes to this line of cases that we're not willing to do that to solve this particular problem.
Okay, so on that front, when they're an easement holder, their duty is to us. When they capture and collect and direct water in an underground pipe to our property, it is their duty to make sure that water stays in the easement. That is their duty. Just like if someone drives on our property via right-of-way easement, they can't go outside of it. This goes back to basic easement law in that the easement holder cannot burden the servient estate. And if the solution here isn't immunity or anything like that, the solution is if they don't want the corresponding duty to maintain their easement so that the water not overflow and flood our property, they don't take the easement. And so as far as the enforcement that you asked,
Miller, can I ask another question? So are you saying that I think I'm getting this, that in order Beatty just doesn't conflict with Rich or ex parte City of Orange Beach? Is that your argument, that Beatty is just a different animal? It's different because of the easement. Is that what you're saying? In other words, would we have to overrule any cases in order to rule in your favor? I'll just ask it that way.
No, Judge, you wouldn't, because if you look at the cases like the Kennedy case and the Long versus Jefferson County case and the Sullivan case I mentioned, all of the cases involving a city exercising its authority to drain says they can be liable. The Kennedy case is very clear that municipalities don't have to provide stormwater drainage, but when they do, they are subject to a duty of care. And so what we have here as far as the enforcement, does that answer your question?
Well, is it the easement that's the difference?
No, in general, substantive immunity does not apply to drainage cases. The times that it's applied would have been in the Brick case where the city of Hoover didn't put that drain in. The developer did. And so no duty was owed there. They had substantive immunity. The plaintiff in that case was trying to get the court to force Hoover to take responsibility. And same with the Muscle Shoals. It had nothing to do with an easement. And in fact, I will note here
Mr. Miller, you're about out of time if you want to wrap up your comments.
Yes, so I've just wanted to note that as far as the Beatty case and the duty to maintain, even if this court finds that we have to provide evidence of negligent construction or negligent maintenance, I would note that in Beatty, the court used the word duty 5 times, and every single time it was applied to maintenance. A breach of their duty to not overflow and flood adjacent property is negligent maintenance. And that's what we actually alleged in our complaint, Justice Cook. You will see we did not bring any claim related to the Shoal project. They are simply trying to tie that to this case in order to obtain substantive immunity. And I would also note on their argument regarding statutory authority, the court in City of Birmingham specifically noted Beatty did not turn on a municipality's liability acting under statutory authority. And the reason for that is because when it's based on an easement, then the duties and standard of care applicable to an easement holder, they apply. And in 115050 doesn't change their status as an easement holder, nor does it change the duties that they owe as an easement holder. And based on the court's holdings in Beatty and City of Birmingham, it's clear that the city had an easement, it therefore had a duty, and it was subject to those duties. And the way I would look at this is the court should look at what the drain rights are derived from. If they're derived from an easement, then there are duties that apply there to maintain and not overflow. If it's not derived from an easement, then 115050 comes into play. And at that point, you have to look at negligent maintenance, negligent construction. And I think a good way to imagine this is imagine that 115050 was never enacted, or next week it gets repealed. In either of those situations, the city would still have drain rights here because their drain rights are derived from an easement.
So the surcharging actually came out of a pipe that came across your property, right?
Correct.
And that's not owned by the city, right?
No, it is. This is no, the property's not owned by the city. They have an underground
the pipe across your property that's connected to the easement, that pipe where the inlets were off of, that's not their pipe, right?
No, it is. That's the thing.
Isn't there a fact dispute about that?
That is not in dispute. There's a 12-foot wide easement here, and their pipe runs in this.
Right, but the inlets, the surcharge were in a separate pipe that connected to the easement pipe, right?
No, Justice Cook, they're right here and right here. That is a part, you may be getting that from a part of his summary judgment motion, which Ben can confirm.
Okay.
There was some confusion there between him as to what we were alleging, and we actually withdrew that argument at the beginning. And if I could just one more sentence, Justice Stewart, I want to note that in the Beatty case, the court said this duty is to maintain so that water does not overflow and flood. And they acknowledged that perhaps that means removing debris, or perhaps it means adding additional pipes. And the court even went so far as to say, and if neither of those work, as a last resort, the city can fully encapsulate their drain pipes so that it is impossible for water to flow out of the easement. And that's because their duty is to maintain so that water does not overflow and flood adjacent property. It is consistent with basic easement law.
Would you be happy if they just closed the inlets?
Yes, I would love that. We're getting 3 feet of water in our home, in our children's play area, and it's happening annually, sometimes multiple times a year, and I witnessed it. It's coming out. Their expert said their pipe is surcharging. It is overflowing. Their expert said what we're
Mr. Miller, I know this is very personal, but
okay.
thank you very much for your time. Madam Clerk, if you'll add the extra time that Mr. Miller went over, please, to Mr. Presley's time.
Thank you, Your Honor. I'll pick up on the last thing that was said right there, which I think is interesting. Would you be happy if we closed the drainage outlets on this piece of property? That is exactly the issue, because what would happen in that situation is you just push the problem upstream to the next resident who's right beside them, where the pipe is still the same section of pipe, that's been maintained by the city, no obstructions, no blockages, and you just push the problem off to another resident. That is what the city has struggled with for over 2 decades over the course of multiple drainage studies that have been conducted in this area. The problem is, and that's why Shoals project was a 3-phase project. You have to account for the fact that when you increase a pipe size upstream from where there is a flooding problem, you better increase the pipe size downstream before you make any improvements upstream. Otherwise, you're just sending more water into a bottleneck. And that's part of the engineering challenge that the city has not ignored, but it's a reality. The city has studied this issue and has determined in its discretion that this three-phase project was not in the best interest of its citizens, given the cost benefit. And I know there's a dispute about whether the Shoal project was a part of this case. I think if you look at what we quoted in our reply brief with respect to the allegations of the complaint, which repeatedly mentioned the Shoal project, discovery responses, summary judgment arguments, but most importantly, those arguments carried the day in the trial court. The trial court judge, in her order, specifically held that Shoal's remediation plan was reasonable, which is a problem in and of itself when you're talking about all the considerations and you're making that finding as a matter of law. But it was reasonable, and it was negligent maintenance for the city not to have moved forward with that plan.
Mr. Presley, let me just follow up by to ask, how can this permanent injunction be enforced? I mean, what steps could the city take to enforce an injunction that says don't ever flood this property again?
I don't know, Justice Sellers. The only engineering evidence in the record about what could be done out there is the Shoal three-phase plan. Even Shoal said that's not going to fix the problem at 2801 Montevallo Road. And it really brings into focus, your question does, the problem with this injunction. Because what happens when the city gets a permanent injunction, goes out and says, okay, what are we going to do? Let's go spend $6 million and let's do the whole Shoal project. We'll bring everything we can up to current day standards, maybe even beyond. And then a week after that happens, there's a rain event that overwhelms those same pipes after $6 million just got spent. And because they're in an easement, there's a strict liability standard and permanent injunctive relief again, and the city has to go back and say, rip it all up, let's try again. I mean, that's the fundamental problem, and it's why a strict liability standard is not the standard and has never been the standard, regardless of whether stormwater infrastructure is located in.
What is the standard? I mean, I really want to know what your duty to the plaintiffs is.
A city's duty when they decide to construct or maintain stormwater infrastructure is they cannot construct it or maintain it negligently. In the context of negligent maintenance, this court's case law is clear. That involves situations where there's an obstruction or there's a collapsed pipe or there's some type.
There's evidence that water is continually to come 3 feet above the ground. And you directed it there, right?
No, respectfully not, Justice Bryan, not unless the cause of the water overflowing the pipe is directly linked to an issue of maintenance. The issue here that's being pressed is indeed one of design and construction. It is that these pipes are outdated and undersized due to development that has occurred since they were installed. And so that is a distinct theory of liability. It is a design construction theory of liability. Injunctive relief is not available for a design and construction theory of liability because it's an unabatable nuisance. The statute of limitations is different. It's 2 years from the first date of injury, which explains why, in this case, the plaintiffs, rightly so, characterized their claim as a negligent maintenance claim. And I say rightly so, meaning they understood that a negligent construction and design claim would be time barred. And so they're smart and they characterize it as a negligent maintenance claim. The problem is that doesn't stand up under this court's case law. Long and Bird make it crystal clear that an allegation that stormwater infrastructure needs to be upgraded and enlarged is one of design and construction.
Does the argument, I'm interested in hearing your response, the argument that this easement makes a difference that was just made, what's your response to that? That this is fundamentally different than a substantive immunity case? This takes it out from under it because there is an easement.
Makes no difference, Justice McCool, and the reason for that is under 115050, which expressly gives cities the ability and the right to create stormwater infrastructure, it contemplates stormwater infrastructure being on both, quote, public and private property. The very next code section allows cities to acquire easements through condemnation proceedings. Yeah. Have I answered your question, Justice McCool?
Do you want to finish your sentence?
The only other thing I would say, Justice McCool, is that the negligence standard that applies to a city's conduct when they act under authority of 115050 is well settled and applies regardless of whether it's in an easement or city property. Thank you.
Thank you, Mr. Presley. Thank you very much for your time today, and we will take this case under submission.
All rise. The court is adjourned.